Well, thank you. First, let me thank the Virginia Mountain Valley Lawyer Alliance for extending me this invitation to speak. I applaud your commitment to professionalism and to your desire to constantly learn more about the law. I see now we have over 284 participants, and apparently it sold out about 5 weeks ago. That was certainly not because of the speaker, because I doubt that 5 of you have ever heard of me. The attraction was the opportunity to learn more for the benefit of your clients. In 2020 and this year, the General Assembly passed a number of firearms related bills. These bills have markedly changed the responsibility of gun owners. And I think it's necessary to understand not only the laws themselves, but also the context of those statutes. So we'll be covering some of the newer statutes and the existing statutes. I also want to make this disclosure up front. I am a lifetime hunter and shooting enthusiast. Therefore, I bet that some of you will be waiting for me to launch into a full-scale "the barbarians are at the gate" mode. Sorry to disappoint. That's not my job. My job is not to praise or criticize the bill. The Virginia CLE Board has wisely decided that you will not receive 2 credits for listening to my political opinions. My job is not one of cheerleading, but rather of analysis. Secondly, I'd like you to consider this. I bought my first handgun in 1977. It was, as my grandson would say, easy peasy. No background check, simple cash transaction. However, on that day in 1977, I had no reason to believe that I would ever be able to conceal that revolver as I walked through Virginia. So today I am required to participate in a background check when I buy or sell a firearm, but having a concealed handgun permit, I can conceal my 9mm under my jacket, legally travel in many, not all, but many places in Virginia. You see, it hasn't gone all one way or the other. What you're about to hear will be my genuine attempt at objectivity. Any opinions I express today will not be political opinions, but rather my opinions as to the meaning of these statutes. There's a dual purpose to this presentation. First, representing the person who has been charged with a firearms-related offense, and secondly, advising your clients, your friends, and your relatives as to their obligations under the law, as well as their rights. A couple program notes here. The last 2 times that I gave this presentation, I tried to read all the statutory citations. That takes too much time, and besides, I'll say it so fast you can't write it down. You've been given 2 scripts. One is the script, the other is the outline. I would really look at the outline. That's going to be easier. It's a lot shorter, and that will give you all those statutory citations, which I've given you. So with that aside, let's go on and talk about our first subject. We're going to talk about sales, gifts, and transfers of firearms. In 1961, my older brother went to a gun store about a mile from our house in Fairfax County. When he got there, he pulled out a wad of cash, purchased a 222 centerfire rifle, a case, and some ammo, and then he walked home. Why did he walk home? Well, he sure couldn't drive. He was only 15. The world was a different place in 1961. I'm not saying that the world of 1961 was perfect or even better. I'm just invoking the observation of a noted historian who said, the past is a foreign country. They do things differently there. The world with respect to firearms has changed. As I said a few moments ago, sometimes to add responsibilities to the gun owner, sometimes to provide more rights for the gun owner. One of the changes has been to try to keep firearms from persons who are legally disqualified from purchasing or possessing firearms through background checks. In 1993, the federal government passed the Brady Bill requiring a background check for the purchase of all non-antique or replica firearms from a commercial dealer. In 2020, the General Assembly expanded that, which requires background checks for the sale of firearms between private individuals. Even though both laws have the same goal, I'm going to discuss them separately. So maybe John can, at this point, can put up that 4473, which is the first exhibit we have.
Yes, sir, we can do that.
All right. We're going to walk through the purchase of a firearm for those of you who haven't purchased one recently or ever. You will appear before an FFL. That's an important term, Federal Firearms Licensee. You will fill out the 4473 that you see before you now, and the state form, which is the SP 65. we're going to look at that 4473. The first thing that they're really concerned about is under number 21. Are you the actual purchaser? Are you the actual transferee purchaser? This is described on pages 3 through 6. We don't need to go over there now, but on page 4, it states that a person is the actual transferee buyer if he or she is purchasing the firearm for himself or herself, or it can be purchased as a bona fide gift. It goes on to say that a gift is not a bona fide gift if another person offered or gave the person completing this form money, services, or items of value to acquire the firearm for himself or herself, or if the person is prohibited by law from receiving or purchasing that firearm. Now, a violation of this is called a straw purchase, and it's a felony which is punishable up to 10 years in prison. There's an important case involving this principle. And matter of fact, it came out of the Roanoke area.
Greg,
Bruce Abramski, I'm sorry.
For a second. I've had one person tell me they can't hear you.
Really?
But no one else has said that's a problem. So I'm going to suggest if you're having trouble hearing Greg, try logging out and logging back in again. Also, if your camera is on, please turn it off so that we're able to concentrate on the speaker. So,
John, they might also need to check their speakers, check which speaker the sound is being.
She could hear me, she just couldn't hear Greg.
Yeah.
Okay, sorry for the interruption, Greg.
Oh, that's okay. John, can you hear me well enough?
I can hear you just fine.
I can hear you too, sir.
Okay, great.
And other people have said it's fine. So I think sometimes the Zoom connection might be unstable on someone else's end. And
Yeah,
once again, if you have your camera on and your name isn't Greg Porter, please turn it off.
All right.
Some people either are not paying attention or don't know how to turn their camera on.
I'm sorry, Greg.
No problem. All right, let's go back and talk about Bruce Abramski. Bruce was living in the Roanoke area, and he's talking to his uncle, Angel Alvarez. Uncle Angel says he wants to buy a Glock 19. Bruce says, hey, I can get it for you wholesale because after all, I am entitled to the Glock Blue Label discount, which is reserved for law enforcement officers and armed security guards. Bruce was wrong about this. He didn't qualify for the Blue Label discount, because of the fact that he left the force 2 years before. But at any rate, Uncle Angel sends Bruce a check for $400, which was full price. Bruce goes to the gun store, undergoes a background check, buys the weapon, and causes it to be shipped to his uncle in Pennsylvania, who also underwent a background check when he picked up the weapon, and the transaction was completed. Now, sometime later, Bruce was the suspect in a crime, and his home got searched. The receipt for the Glock was found, and when questioned, where is the Glock, he described what the transaction was. Bruce was arrested and later convicted for violating the Gun Control Act of 1968, prohibiting straw purchases. So you look back to that form 4473, and it says, are you the actual buyer transferee? Warning, you are not the actual transferee buyer if you're acquiring the firearm on behalf of another person. So the question is, did Bruce have the right to buy this gun? Well, clearly not. I mean, on its face, it looks simple because we know that he was buying it for someone else. Was it a gift? No, because as soon as he bought the gun, he went out and cashed his uncle's check. But there was a little bit of a nuance to this case. Was this purchase illegal in a case in which the ultimate transferee was legally qualified to purchase a firearm? In other words, when Bruce said that the gun was for him, but it was actually for a third person who also was eligible to buy the gun and who also underwent a background check, was this in fact a material misrepresentation? That sounds like a stretch, but before Bruce completed this transaction, he talked to 3 federal firearms licensees, and they all told him his plan was illegal. As a matter of fact, 2 or 3 circuit courts of appeal had ruled that such a purchase/transfer was legal. And when his case went to the Supreme Court, 26 states filed briefs in support of his position. Bruce entered a conditional plea of guilty, was convicted, and was sentenced to 5 years probation. Case went up to the Supreme Court, and by a 5-4 vote, with Justice Kennedy siding with the liberal wing, his conviction was upheld. For what it's worth, not that my opinion is worth much, but I think they got it right, because to rule otherwise would have gutted this important law designed to ensure that guns do not fall into the wrong hands. However, I do feel bad for Bruce, but there's a warning here. Not only do laws change, but legal interpretations change. What had been considered lawful conduct can become a crime. We're going to come back to this. You may disagree with this decision, but you can't reasonably disagree with this. The government is taking this situation seriously. Your clients need to know that they cannot expect a lot of slack when they make a material misrepresentation on these forms. Now, there's a few other questions on this form while we have it up. Some, such as mental impairment, I'm not going to go over, but I would like to look at a couple more. Let's take a look at page 121C. Have you ever been convicted of a felony? Now, I just noticed something the other day. On page 4 of the instructions, it tells you that this disqualifier does not apply if you were convicted of a federal or state antitrust statute or an unfair trade practice or other business practices. So therefore, from the standpoint of the federal government, you're not disqualified, but from the standpoint of Virginia, you are. So you have to be careful about that, because you might be qualified under state and not be qualified under the federal government. One other thing about this, if your client is able to get a restoration from the circuit court, the instructions of this form tells them to answer no to this question. Page 121E, are you an unlawful user of or addicted to marijuana? Does it say frequent, habitual? Does Virginia legalization affect this? Well, I suppose it depends on where you smoke, because if you go on a national forest in Virginia, it's my understanding of the law, that's on federal property and it's still a crime. So the people who want to smoke marijuana, even though it's about to become legal in Virginia, need to be really careful about that. And if you think, come on, what are the odds they're going to catch me? Think back to Bruce Abramski. He was wrongfully accused of a crime and the charges were dismissed, but as a result of the search, he received that felony conviction. Page 121I, have you been convicted of the misdemeanor crime of domestic violence? Okay, that's pretty obvious, except you need to read those instructions or go back and read the Gun Control Act of 1968, because it tells you that even if a person's been convicted of domestic violence, they're not prohibited from owning a gun if they were not represented by a lawyer, or if they gave up the right to be represented by a lawyer, or if they were entitled to a jury and gave up the right to a jury trial. I didn't say that well, but what I'm saying is look at the papers, look at the warrant of arrest, see if the person waived counsel. If there's not a waiver on counsel on there, your client may not be barred from owning a gun. Likewise, did they knowingly, intentionally waive their right to a jury trial? And you're going to say, but in Virginia, misdemeanors aren't entitled to jury trials. Yes, they are, if they're appealed to the circuit court, or your client could have been convicted in another state. So those are two important exceptions that you need to look at when a person believes that they are federally disqualified. Let's take a look at the state background check. The biggest difference between the state background check and the federal background check is that the sale of new guns usually takes place with a federal firearms licensee, usually at a commercial gun store, sometimes at the FFL's home, but usually at a gun store. Most FFLs aren't going to try to avoid the law to help a customer get around the requirements. On the other hand, someone who already owns a firearm can agree to sell it to another individual who is equally willing to avoid the requirements of the new law. Today, I want to give you some advice as to how to encourage your clients, your friends, and your relatives, and yourself to obey this law. I'm not going to sugarcoat this either. I think there's a lot of gun owners who don't like this law, but that's tough it is still the law. So why do you need to obey this? Because one, it's a law, and a violation of it is a crime. It's a class 1 misdemeanor. And two, what if you sell a firearm to someone without a background check? Do you expose yourself to civil liability, particularly in light of the fact that the state of Virginia has redefined the standard of care for firearm sales? And then we have another statute which provides that any person who sells, barters, or gives or furnishes any firearm to anyone he knows is prohibited is guilty of a crime. Now, I quoted that statute. Who knows the person? Does it require actual knowledge? I think so, but could that later be interpreted as who knows or should have known with a background check that that person was disqualified? So again, think back to Bruce. You don't want to be in a position where you're hoping against hope that you don't get charged with a crime. Do the background check. And I would also say that for most of us, if we're honest gun owners, we want to make sure our guns do not fall in the hands of anybody except a responsible armed citizen. And I think that's another good reason for a background check. 5, do you really want to sell a gun to a stranger behind the Walmart 10 o'clock at night, handing him a 40 caliber revolver and a box of ammo and then demanding $1,000? Number 6, I think, is important. This gives you cover for asking for a background check. 2 people come up to you. One is a friend, the other you don't know. You ask for a background check from the person you don't know, and now they're taking it personally. This allows you to say, I'm sorry, it's not me, it's the government. They want me to have you undergo a background check. And then the last thing I would say is just make a joke of it. The dadgum government did not order you to attend a 3-hour ballet. They're sending you to a gun shop. Don't you need ammo, gear, knives, and clothing? So go ahead and go to that gun shop and have the background check. And while you're there, maybe they can buy the ultimate firearms accessory, which is a firearm safety course. What I'm asking you to do is to know the statute, explain the statute, and yes, sell the statute. Now, you'll notice that there's an exception for gifts. And I think that's an important exception, perhaps. The example I gave was, what if a friend of mine who's an attorney does a lot of criminal law, and I don't do the heavy-duty criminal law, so I refer a big case to them. And then a couple weeks later, he comes by the house. He's got a big box and a card. When I open up the card, it says, "For all you do, this Ruger's for you." Is this a sale or a gift? Now, he has bought the gun for me. He did not have a legal obligation to give me a gun or anything else. But could this be seen as a referral fee? I wonder if he wrote it off on his taxes as a business expense. Does he expect further referrals? You know, there's a lot of money flying around there. An investigator could conclude it was a sale. Let me give you another example. What if your nephew's been working around your farm or house for a couple of weeks and you buy him a shotgun? Is that a bona fide gift? Divorce attorneys. Mary's husband leaves her and a shotgun behind. He tells her that he doesn't want the shotgun. Several couples come over to help her to move. She tells one of the people that she can have the gun. After helping Mary move all day, is this really a gift? You know, we could come up with a lot of these fuzzy hypotheticals, and you get to the point where you question, could you ever safely and legally buy a gun for another? Yes, I think for your spouse and probably your adult child. You know something? Even then, I would have them fill out the paperwork. The government really doesn't care who pays for it. They want to know who's ending up with this gun. Whose gun is it? Several weeks ago, I bought my wife a shotgun. I paid for it. She underwent the background check. So what is the answer as to whether it's a gift or a purchase? I got 2 answers for you. If you're defending a client for a purchase that has already occurred, argue gift as long as you have any plausible facts. Find some cases and maybe you can plea bargain it down to something your client can live with. But if the client asks you before the purchase, well, I would refer them to one of the cardinal rules of firearm safety. treat all guns like they're loaded. In this case, treat the sale as if it is a sale and not a gift. All right. If you want to give a firearm to somebody, let's say it is a relative, a more distant relative, you know what a better option would be? Give them the check or take them to the gun store, because that would be the safer way to do it. And then finally, I want to talk about loans and other transfers. The bill that passed the Virginia House would have covered all transfers. The Senate couldn't accept that, so transfers were excluded, but I would still be careful. Now, I don't loan out guns often, and that's for reasons totally unrelated to the law. But if somebody is hunting with me for the day, or we go to the range with me all day, I don't have any problem with letting them use my gun. But if they wanted to borrow the gun for the season, if they wanted to go on a trip, if I'm not going to be there, I want to say, let's treat it as a sale. That's a fairly conservative interpretation, but I'm comfortable with it. We're going to move on to lost or stolen firearms, 18.2-287.5. This requires a gun owner to report the loss or theft of a non-antique firearm within 48 hours after the discovery of the loss or theft, or after being advised by a person with personal knowledge of the loss or theft. And the violation is a civil fine of $250. No big deal, right? I disagree, because the statute goes on to say that any person who in good faith reports the loss or theft of a firearm is then immune from criminal or civil liability for acts and omissions that result from the theft. So what does that say if you don't report it? If somebody steals a gun out of my car while I am off somewhere and I don't report it, could I be later held responsible for the actions with that firearm? Perhaps, but if I report it as lost or stolen, then I have, it seems to me, absolute criminal and civil immunity. Doesn't this law actually help gun owners? Now, this is a good time to advise some of you who are not familiar with firearms laws that, with some very limited exceptions, firearms are not registered in Virginia, which means that all gun owners should keep a complete list of their firearms to include the manufacturer, the action, whether it's pump or bolt, etc., the caliber or gauge, and the serial number. After all, if your weapon is stolen and later recovered by the police, how can you prove that it's your weapon? I have a Marlin 99C semi-automatic 22 rifle, and there were hundreds of thousands of those things sold over the years. The chances that it would be recovered to me would be,
Excuse me, Greg.
yeah.
Can I cut in here? We've got a couple of questions. I just wanted to give
Sure.
them now if I could. First of all, it says, what about loaning a gun to a family member or child as part of a shooting experience? I'm assuming they mean, and you wouldn't be there to supervise.
Can I ask him a question a little bit? When you I need to find out what he's saying.
I would say, first thing I have to ask about the child is how old is the child? We're going to cover that later on, because if the child's under 12, they cannot have a gun without an adult present. And there's also liability for children under 14. So I would be extremely cautious about saying too much until I found out the age of the child. In terms of loaning a gun to someone, you can lawfully loan a gun to someone. Again, maybe it depends on how long the loan is for. But if you're not going to be with them, I don't know.
Yeah, I mean,
I know that the House.
I'm thinking this refers to maybe like a family outing where you're just loaning them the gun for the day, and you're all going to be off in the deer stand somewhere or something. I think that's probably fine.
Probably, but the term child came up, so I think I would want to know, what is that person's level of experience? Has that person ever fired a gun before?
Yeah. And then the other question, which this is the sort of thing only a lawyer would think of, and yet I think it may be something that the law doesn't address. What about testamentary dispositions of guns? If I leave my gun to my nephew in my will, I mean, obviously I'm going to be dead, so I don't know why I care, but
I would hate to get hurt,
he might be a felon in possession.
but I hate to get hurt.
Hi, it's David Weber. I just wanted to say, Greg, I'm sorry to interrupt. I'm super interested in this. John, it's not an obtuse issue, particularly for people who practice in Northern Virginia, because Maryland considers all handguns and all modern sporting rifles to be quote unquote regulated firearms. So if somebody dies and they own one and it's transferred either as part of the residuary of the estate, Maryland is very, very strict. Like the executor cannot put their hands on the weapon without a handgun qualification license. So I do want to point out, I mean, it's a serious question that the other person asked, and I really would like to hear what Gregory says about Virginia law.
Well, there's so many different ways to look at this, but David, you really raised some good points, particularly anytime you cross state lines. That was one of the things I was going to mention before. I'll just go ahead and say it now. You have a divorce case and your client calls you up and says, look, I'm moving. Can I take the guns with me? You better find out where the person's going. For these testamentary matters, I would say the first thing you do is get an FFL involved. Contact a federal firearms licensee, and they will be able to advise you as to how to handle this. But David's right. Just to go over there and start loading up the weapons depends on what state you're in. It could have bad consequences.
And one more question, which may be something you're covering in this course or not, is about persons convicted of domestic violence. If they're in a diversion program, first offender diversion program, are they still considered convicted for purposes of firearm application?
No, they're not, according to my opinion. We just raised this issue the other day. I was in a seminar and somebody offered the opinion that if you enter into a suspended imposition of sentence, an SIS under 18.2-57.3, I don't have my hands on that right now. I'm going to come to it later. Maybe I don't have to. But it says that it's treated as a conviction under Article 6.1. So that person interpreted to mean that you cannot own a handgun. Actually, if you go and look at that statute and then track down Article 6.1, you're going to see that Article 6.1 relates only to concealed weapons. So it's my opinion of the law that if a person enters a plea of guilty to domestic assault and battery, the case is continued for 2 years, they are not prohibited from owning a firearm, but they are precluded from having a concealed handgun permit. If anybody's got any case law or authority to the contrary, I would like to see it, but that's what I have come up with. Okay, by the way, if you have a client who gets denied the right to buy a gun and they think they have a good reason, if the state police agrees, then your client can apply to the Virginia State Police Firearms Transaction Center. I've dealt with them a number of times. They're great people to work with. If your client is eligible, but they always get disqualified on the record, they can apply for a unique firearms identification number. And according to my schedule, I've got about 30 seconds left on this one. The control of firearms by localities, this became important this past year. Now localities have the right to ban guns in the government buildings, community centers, public streets, roads, alleys next to permitted events or events that could require a permit, and then in any public park owned by the locality. Be careful about this one, because I don't see any exception in the statute, at least the one that Fairfax County passed, which was based upon the model language suggested by the General Assembly, that says there's an exception if the gun is cased and unloaded. You know, under the Federal Gun Control Act of 1968, if I'm going hunting in Maine, as long as I have a hard case for my weapon and my gun is unloaded and locked in that hard case, and I put the ammunition in a separate hard case, and that too is locked, then I can drive even through New York City, theoretically, though New Jersey and New York City do not recognize this law. Theoretically, under the federal law, I'm legal as long as I'm just passing through the state. That's not the case from what I can see. If my wife calls me to go pick her up over at Burke Lake Park or one of the other parks, and I have a gun in the car, I'm guilty of a Class 1 misdemeanor. All right, and that covers our topic on sales. John, I'll wait for you to tell me if there's questions or if we go ahead.
Yeah, I'm trying to see this. Somebody says, read domestic violence. Doesn't the federal law prohibit possession by a convicted person regardless of state law?
Yes.
I think they're referring back to the question about the diversion. But I think the answer there is the diversion does in fact result in the record being expunged if you complete the requirements. Isn't that right?
Well, not necessarily expunged.
Oh.
It does not result in a conviction, but the person was absolutely right. That is referred to as the Lautenberg Amendment after Senator Frank Lautenberg of New Jersey, the late Senator Lautenberg. And that is the one that says that anyone who is convicted of domestic violence with respect to certain individuals, such as a spouse, they are forever barred from owning a firearm, at least a modern firearm. Can they own some firearms? Yes, we'll cover that later.
And then the other thing I would mention is the Goebel case that's coming up with respect to the state police database. Goebel versus Department of State Police, where someone brought suit for an injunction after the state police declined to modify their record. And the Supreme Court has granted review on that case because what happened was the state police claimed that they were immune from prosecution for someone seeking to correct their record. And the argument on appeal, I believe, is that because it involves a constitutional right, sovereign immunity doesn't apply. But that case will be argued later this year.
Oh, okay. I wasn't familiar with that. I'll follow that.
Yeah, it's just got granted within the past month or so, and obviously won't be on the docket probably until October. But it's something to look forward to, I guess.
All right.
I'll mention just very also someone says, how does one learn about these local ordinances for like the parks and stuff? I guess you just have to go online and check.
You need to go online to check. You can read the Virginia game laws. I was in a situation, it was about 3 years ago. I'm walking out of the National Forest. I'm within 50 yards of my car and the road, and I hear boom, boom, boom. So by the second boom, I'm screaming, don't shoot, hunter, and everything else I can think of. I go up there and it's a guy target practicing on the National Forest. And I said, you can't do that. He said, well, I didn't see a sign. So I went back and I got the game laws and I pointed it out to him and he apologized. But it's your responsibility as a gun owner to know where you can shoot and where you can't shoot. So on the parks, I know in Fairfax County, they're supposed to put up signs to say that you can't have a gun there. But with so many of the parks, there's so many possible places you could enter that it is very easy to violate. So you just need to know, has your county or your city passed that particular ordinance? Okay, we ready to move on?
Yes, I believe so.
All right, let's go to one handgun per month. This is actually a misnomer. It's one handgun for 30 days. This is a restoration of a former law, but there's a lot of exceptions. It doesn't cover situations between the same buyer and the same seller within 30 days. I go to buy a 40 caliber and I come home and I decide that I'd rather have a 9mm. I can go back and exchange that and it won't trigger the law. Persons can be issued a certificate by the state police with an enhanced background check. This is really for bulk purchases from a state, collectors, things of that nature. So if you have a parent who wants to give 3 handguns to his 3 adult kids, can he use this method? No, that's not the purpose. Also accepted are law enforcement officers and agencies, state and local correctional facilities, licensed private security companies, and it doesn't apply to the purchase of antique firearms. We're going to talk about antique firearms in a little while. Persons whose handguns have been stolen or lost if the replacement is deemed essential. Let's say you have an armed security guard who is certified for a 40 caliber semi-automatic, and he loses that. He can't carry a 9mm. That's beyond his certification. So that would be a situation where it'd be deemed essential that he replace it. Also, people who are trading in a handgun. So I can go trade in one handgun, buy another handgun that day, and buy a second handgun. In other words, I went from one handgun to owning 2 handguns. That's fine, but I can only do that once a day. Purchases of a handgun in a private sale. So it doesn't apply to private sales. Okay, that was a gotcha, because I wanted you to think that it didn't apply to private sales. If you are giving someone advice on this, you've got to have that statute in front of you, because when you look at this, the rest of it goes on to say this is limited to curios and relics. And curios and relics are defined in that statute. I'm not going to read it to you, but I'm going to tell you that probably 98% of us do not have a curios or a relic. And then the other one is persons with a valid concealed handgun permit. So if you have your CHP, you get to opt out of this law. And that is the biggest exception to this. But even then, you need to understand Virginia's shall issue concealed handgun law to understand the importance of this. Are there any questions on the 1 handgun per month rule?
It does not appear so.
I don't think
All
so.
right. Okay, let's go on to the concealed weapons law, the CHP, concealed handgun permit. Most people don't consult with an attorney before applying for a concealed handgun permit. If you're having this discussion with somebody, it's probably because you're applying for a permit, one of your friends or relatives is discussing it with you, or you have a client who's not been charged with a crime and they're inquiring about the statute. Maybe they were denied a CHP, or you might have a client who has been charged with a crime. Now, for the context of all of this, I want to explain the 3 models of concealed carry that we have in the United States. All of them have features that some people like and that some people don't like. So instead of telling you what I like and I don't like, I'm going to use the some people like, some people don't like model. The first is constitutional carry. This has been in the news recently because Texas just adopted constitutional carry. It is also the law in West Virginia and Kentucky and about 21 other states. No permit is required. So some people like the fact that there's no government interference, and it is gaining in popularity. Some people don't like the fact that someone who's never fired a gun can go into the store, buy a 9mm, a box of ammunition, ask the sales clerk how to load it, walk outside, load it, jack one in the chamber, and go walking up and down the streets, having no knowledge of gun safety or no knowledge of the rules of the use of deadly force. The second model is that of the may issue statute. This is Maryland, New York, and a few other states. Some people like the fact that one has to show a good reason to have a concealed weapon, and the government gets to choose who has that concealed weapon. Some people don't like the fact that the government has the absolute discretion to deny it to everyone. A number of years ago, before Virginia had a shall issue statute, here in Fairfax County, with a population of 1 million people, we had one person with a concealed handgun permit. His name was Oliver North, and then he moved over to Clark County. So the answer was always no. Some people don't like the fact that it becomes somewhat of a buddy test. Who do you know? Who are you in church or synagogue or mosque with? Who do you play golf with? And then also, some people don't like the fact that women, minorities, people with accents other than Southern accents, or on the basis of religion can be discriminated against. This is going to be a hot topic in the Supreme Court session coming up, because this case has gone to the Supreme Court. The New York State, I think it's New York State Rifle and Pistol Club has filed suit, and the Supreme Court is going to review this case as to, can the state lawfully, constitutionally make this decision for people as to whether or not they can carry. Now, not going to try to start an argument, but in case anybody wants my guess, here's my guess. And it's a guess. My personal thinking is that the statute's going to be struck down. I think the New York statute's going to be struck down, but I think that the Supreme Court will state that the state, or in this case, state of New York, can impose such restrictions, such as who qualifies and what training period is required. For example, in the District of Columbia, one has to have a 2-day training period, and that also includes a live fire exercise. And then finally, the third model is the shall issue statute, such as Virginia and the District of Columbia. Some people don't like the fact that you don't have to show a good reason. Some people like the fact that you either meet the objective criteria or you don't. Doesn't matter who you know. They're going to write the rules before the game starts, then we're going to decide whether or not this person qualifies. Again, my job is not to get you to think like me. It's so you can have the information to think for yourselves. Now, with Virginia being a shall issue state, you either meet the criteria or you don't. So the first question is the person 21 or older and able to legally own a handgun? Secondly, is the person disqualified? Those disqualifiers are found in a particular statute. I'm not going to hit them all, but there's some that you would expect, such as felony conviction, domestic abuse convictions, protective orders, mental incompetence, or if you've had 2 or more misdemeanors within 5 years, if one was a class 1 misdemeanor. If you're an illegal user of drugs like marijuana, if you've been convicted of DWI, drunken public, assault and battery, sexual assault, brandishing within 3 years, dishonorable discharge from the military, or a stalking conviction. Number 13 is a catch-all. The sheriff, the chief of police, or the Commonwealth attorney can submit to the court a sworn statement to show why the person should not have a permit. I wonder if this is used very often. I could think that they could really get into some trouble on this, depending on who they're making this claim against. And then the last is if a person's been suspended or revoked pursuant to the particular statute. Then if one passes all those tests, we move on to the demonstration of competence criteria. There was a change last year. Effective this year, you cannot use an online program. You have to have an in-person program. In talking to your clients about this, if you have the opportunity to talk to them or your friends or relatives, I would really encourage them to take an in-person class, because there's several other options that supposedly demonstrate competence, which may not. For example, hunter safety classes. I think they're great, but do they teach a person how to handle a handgun? Do they teach the rules of the use of deadly force? What about a general NRA firearm safety class? Did it cover the use of deadly force? How about this one? Almost 50 years ago, I enlisted in the Navy Reserve in an officer program where I was supposed to go to OCS after college. Well, the Vietnam War ended and they decided they were overstocked with junior officers, so I went ahead and took a discharge. I was awarded a DD-214, the Certificate of Honorable Discharge, despite the fact that I never worn the uniform or had a day's training. Based upon that DD-214, I would qualify for a concealed handgun permit. How many of you would be confident of my abilities based upon that demonstration of confidence or competence? Okay, I didn't take that route. What I decided was I wanted to step up my game, so I went through the Department of Criminal Justice Services and completed my requirements for the armed security guard license with a firearm certificate because I wanted to know as much as I could, and I wanted to be as well trained as I could be. So with that in mind, I would like to share with you 5 essential things that a person needs to remember as a concealed weapons permit holder. Number 5 is the person has to know their weapon, not weapons in general, their weapon. For example, I have a Glock 19. The Glock 19 is different. It does not have a conventional safety. In lieu of a conventional safety, you keep it in a hard holster. Person needs to know that or they're going to get hurt. You need to know where you can carry and where you can't. Post offices, no, it's a federal building. Restaurants that serve alcohol, no, if you are drinking, unless you're a police officer. Some parks in Virginia now. Now, the national forest outside of hunting season, yeah, you can carry there if you have a valid CHP. You need to know where you're legal. Your clients need to know that the term brandishing is not synonymous with pointing. Every one of us who do criminal law who's had one of these cases has heard this, but I didn't point it at them. It may not matter. They need to know the rules of the use of deadly force. They are complicated. When I went through my training, I probably got 7 out of 10 wrong on our videotape scenarios, which means that I would either go into jail or I would let somebody die because I didn't shoot. What was my problem? You know, it seems like after 39 years of practicing law and 60 years of hunting and shooting, I'd be pretty good. I wasn't. And the problem is my training is as a hunter. Don't shoot unless everything is perfect. It's like a really strong virus protection on your computer that interferes with the program that you're trying to run. So my position was always don't shoot. But what about somebody whose position, their default position is shoot first, ask questions later? The moral of the story is just because you, your friend, your client is well versed in shooting or hunting doesn't mean that they're competent in combat shooting. I don't mean to sound dramatic, but that's what it is. It's combat shooting. Tell your friend, your client, your mother to get as much training in person as they can. And then the number one thing they need to know is that the gun on their hip is not a badge on their chest. We have seen so many bad shoots in the past 6 months or a year. In Tacoma Park, Maryland, now it's several months ago, a Pentagon police officer killed 2 men he thought were breaking into a car when they drove off. I'm not saying he's guilty or not guilty, but I know one thing, he's charged with murder right now, 2 counts. So your client needs to know the rules of the use of deadly force, and they're only going to get that through a really good program. And the other thing is that if your client violates doesn't get a background check on a gun, they're going to be punished on the sale of a gun. They're going to be punished, but it probably won't be too bad. Probably something you can live with. But if your client violates the concealed handgun permit law by brandishing a weapon, unlawfully discharging that weapon, or worse yet, wounding or killing somebody, then you as the defense attorney may very well end up talking to the Commonwealth attorney who has just spent the last 45 minutes talking to a lady whose eyes are swollen from crying and who does not understand why her son or husband is dead. Do encourage your clients to get that in-person training.
Greg,
And that concludes that portion.
Greg.
Yes.
So 2 questions, one of which I know the answer to, but I'll let you confirm it. The first one is, do you need a background check to purchase a shotgun or a rifle, long gun? And I believe the answer to that is any firearm.
Any non-antique firearm, and quite frankly, if you go to a gun store to buy a non-antique firearm, they're going to do a background check.
Okay. And then the other one, this is a question that comes up all the time. So you have someone who is a lawful gun owner. They subsequently commit some offense or otherwise wind up unable to own their guns. The question is phrased this way. Could they keep them locked in a safe and give the key to a family member? Would the family member need a background check? I'm pretty sure I know the answer to that, but I'm going to let you handle
Is this a marital or non-marital situation?
it. It does not say. It says a family member.
Family member. Because this issue comes up in terms of husbands and wives. One of the spouses is a convicted felon. Can you have guns in the house? And my thought is yes. Now, again, reasonable people could disagree, but my position would be yes, but I would put them in a gun safe, lock them, and that disqualified spouse does not have access to that gun safe.
The excuse me, the questioner qualified. It says non-marital, so I don't know if that means siblings living together, father and son, grandfather and granddaughter. I think the question comes down to more. For example, if you have that gun safe and it's locked by a key, and you hang the key on a peg next to it, that's not going to be good enough.
I agree.
Okay. So it's a more question of access. I will be honest and tell you that I have told people when they've asked me this exact question that that the best thing, not necessarily saying the required thing, but the best thing is just not to have guns in the home anymore. Because depending on, the level of desperation of the person, and quite frankly, the credulity of the police officer or Commonwealth's attorney, the fact that those guns are stored in the home, even if it's in a locked compartment, the officer could very well say, well, I'm sorry, I simply don't believe that the wife has sole and exclusive control. I think if the husband asked her for the key, she'd give it to him and he'd have access, and therefore he's a felon in possession or whatever. So again, this has just been in my personal situations. I've said, if one partner is not allowed to own guns, the other partner still wishes to, get a locker down at the local gun range, keep them in your office, but don't have them where the person who's interdicted can be alleged to be in possession.
And we think we said.
All right.
Hey, Gregory, David Weber again. I'm sorry I'm butting in once again, but I'm a current assistant Commonwealth attorney and I'm a former assistant U.S. attorney. And I wanted to point out that this is not unique just to citizens. This is also an issue for police officers and federal agents, where they have a paramour who maybe is a prohibited party, and it's the exact same issue. What do you do with your duty rig when you come home? And you need to think very carefully about it, particularly with security clearances and other things, because federal agencies in particular become very unhappy if they find out that you're associating with somebody who's a felon if you're a federal law enforcement officer.
All right. What was your answer to the question then, since you're an assistant Commonwealth attorney? What would you say then? Mr. and Mrs. Jones are married. They're living in the same house. She's a convicted felon. What would you say to the guns are in a gun safe and she doesn't have access to the gun safe argument?
I think it's a big problem. I think that I don't think you give up your constitutional right just because of who you're married to. So, but you have to be able to prove that you have complete and utter dominion over the weapon and the spouse doesn't. Okay. So I'm not sure a key works. I guess the person could testify and say that, that the other person doesn't have a key. But if you really, really, really wanted to make it clear, it would either be a code or it would be a biometric safe, like a fingerprint. And I'll just share with everybody, I have a biometric, safe for my pistol. For those of you who don't know, assistant Commonwealth attorneys are considered law enforcement officers here in Virginia and don't even need a pistol permit. And that biometric fingerprint is just mine. It's not my wife's, it's not a child. And nobody else can get into it but me, and I'm the one who set it up. So I think in a situation like that, if it's bolted down, I don't see how somebody could make an argument they could get in. But I appreciate what John said about, somebody could be under the influence or dominion of their spouse.
Yeah, that's why we call it the practice of law. We're offering opinions.
Right. but again, I just want to point out, because so many of us do take on clients who are law enforcement officers. The inquiry for a law enforcement officer is different than for a citizen, and many law enforcement agencies, and particularly because I spent most of my career in the United States government, have suitability and security clearance requirements that are very different than the law, and they do not necessarily allow you to cohabit or frequently associate with people who are convicts or otherwise might pose a suitability or clearance issue. So, I mean, like, I'm very familiar with a case in the district where an FBI police officer was dating a felon, and she lost her badge and her gun over it. I mean, just being in the same home with the person. But it was all the questions we're asking. What does she do with the gun when she comes in the house? Where is the gun safeguarded? This other person is a prohibited party. Where is her shield and credentials, et cetera, et cetera? And she lost her job over that. She didn't get, her security clearance wasn't revoked. What happened is they decided she wasn't suitable. There's a suitability and a clearance part, and they decided that she wasn't suitable to be a federal LEO.
All right. Well, that's good. Hey, John, what do you want to do now? Do you want me to go on to the next section, or do you want to take that 5-minute
You want to
break?
take a 5-minute break? Just let
Okay,
everybody
that's-
stretch or do what they need to do. So we've actually had a question come in. So why don't we answer that? Just a minute. Should we as attorneys be recommending that gun owners keep their firearms in a gun trust? I'm not sure I've not heard of a gun trust. Is that a phrase you're familiar with?
Slightly. It's usually for, oh gosh, NFA guns. It's my understanding they're usually for NFA guns, National Firearms Act, things like machine guns, which you can own, but it's quite a bit of regulation involved in owning one of those. Again, I have not dealt very much with gun trust.
Okay, so let's take that 5-minute break. We'll
Okay.
come back at
Before we-
3:05.
before I take
What
it-
is your question,
Okay,
Joseph?
so the question is, are you saying that if people are not behaving, they have to get taken to jail?
Yeah.
Because they have to call 911, then they need to be the first one or whatever.
No, there's no warnings.
Yeah, if they don't stop with their kids, that could be a hard time.
Joseph is basically asking, if people break the law about guns, do they go to jail? Yes, they usually do.
All right.
All right.
We'll take a little break.
Back at 3:07. I was hoping to, another comment came in. I was hoping to hear clarity on how the VA law change with marijuana will affect gun owners once marijuana is legal in Virginia. As long as it's still illegal federally, I think that's going to be an issue. But that's something that we'll just have to see play out. So go ahead and take the break now, and we'll be back at 3:07.
Does anybody?
Greg, just so you know, I did mute you, and you'll have to unmute when we come back. You're muted, so I can't hear you.
You have to press this little unmute button.
You have to press the microphone.
Okay, got it.
Okay. All right. I'll just leave you on. I just didn't want any background noise, but that's fine.
No, I just figured out the answer to one of those questions about the marijuana.
It- 4 o'clock is when we're done, Joseph. Yeah, if you figured it out, let the judges know, because I'm sure they're going to be struggling with it.
Well, the 4473 says, "Are you an unlawful user of marijuana?" And you want to say
Unlawful.
no.
I would
Because
say yes.
I
It's
do
still
it in
unlawful under
Virginia.
No,
federal
it's
law.
still unlawful. It's still
What?
unlawful. It's still a title. It's still a scheduled title federal narcotic. I mean, until Congress acts,
Yeah.
you can't fill out that ATF form and say no.
That's where I
Okay.
was going, David. I
Oh, okay.
agree with you.
No, and just so you know, I mean, Greg, I'm so delighted to be here and be part of your thing. I'm not trying to step on your toes. I give firearms
No.
lectures all the time,
Yes, David,
and,
we understand, buddy.
and there's just no way, man. There's you can't. How could you, with especially using the example that you just used about giving the weapon to somebody else with that level of uncertainty? How could you say no? And my understanding is the ATF has published guidance, and that there are several directors' letters, and they say that if you use drugs or medical marijuana, that it's just like being a habitual user of alcohol. There's a question on there about alcohol too.
Mm-hmm.
I mean, how can you? I mean, you're clearly habitually using marijuana, in that you have something that requires being treated that could use marijuana. That's not experimental.
I agree with your position.
And it's scary. I mean, that's the thing. So you could have people who are sick, you could have a veteran, you could have other people for whom maybe the marijuana really is helpful, for something, but suddenly they've become a prohibited, person for firearms purposes under, 18 USC 622. By the way, John, this is my first time speaking to you, but I just want to thank you so much for being the host for all of these and allowing those of us in rural Virginia to get our CLEs at such a reduced cost price. It's very meaningful.
Where are you, Assistant Commonwealth's Attorney?
I'm currently Zooming from Chincoteague Island, Virginia.
Wow.
Which is where the wild ponies are, and I'm the Assistant Commonwealth Attorney here in Accomack County, which is a very small county, and we've got the Chesapeake Bay on one side, and we've got the Atlantic Ocean in the other, and we've got Maryland to the north.
I recently saw something on Facebook that had a map, and it showed the map of Virginia, and of course it just showed the regular mainland or non-Delmarva portion of it, and then it had the Delmarva counties over here, and the arrow pointing to it, it said also Virginia. A lot of
that's how we feel. I mean, it's but I mean, it's another planet. I mean, but it truly is another planet. I mean, if you've ever heard of Tangier Island or some of the islands, I mean, with law enforcement, neglected children. I mean, we have to take a helicopter or patrol boat to get out there. Or the Coast Guard. And that's the water right outside my window here.
And this I know from having attended Virginia Tech with a couple friends who were from the Eastern Shore. Don't ever talk about anybody on the Eastern Shore to somebody from the Eastern Shore, because everybody's related.
Except me, because I'm a Jewish lawyer from New York City. So I'm what they call a come here. And I'm
okay. So David Weber, this is Audrey Turner speaking from Richmond, Virginia. And I'm really glad you qualified that you're actually working in Chincoteague right now, because if you were talking about while you're taking a CLE while you're on PTO, my heart was going to bleed from you, as I'm this Jewish lawyer from New York as well.
Well, I'm glad to hear there are others of us who are interested in firearms law, but I am actually working.
Well, yeah, me too. Doing the CLE. It's a fascinating topic.
But I'm 50 miles from the courthouse, and it would take more than an hour. So I frequently work from here, and I'm frequently the only prosecutor on this end of the county.
Chincoteague is a special place, but a far cry from the North Shore rocky beaches of Long Island.
That's true.
Yeah.
That's true. Although we did have our first murder here on the island in 50 years this year.
Indeed.
John, how are we doing on time?
Are we gonna make a club for the Jewish lawyers from New York here?
Oh, no, there's another one and another professor.
Yeah, I thought there weren't any in all of Virginia. I had to go to France.
And so
You're gonna have to
Speaking of firearms law,
okay, so I hate to break up the little reunion, or I was trying
minion, what is it they call it? Anyway, the group of people that were talking there. But we do need to get started back. And I will just mention a couple of quick things here. Number one is if you haven't been able to get the link to the CLE form that's been posted, remember it will be emailed out later this evening. Also, we will straighten out the written materials, get them into one single file, email that out to everybody too. So if you haven't been able to get those links, don't worry about it. I'm going to turn it back over to Greg. And Greg, I assume we're going to be going back to the exhibits at some point.
Yes, we will. Matter of fact, that'll be coming up in this section.
Greg, I'll be
Okay.
right back. I have to use the restrooms. I'll be right back.
I'm going to turn it back over to you, Greg.
Okay, let's go on to forfeiture and restoration of gun rights. Since last year, we've had a statute. It just comes into effect this week. It's effective July 1 of this year. A person will be able to put themselves on the voluntary do not sell firearms list, and that will prohibit them from purchasing or owning or transporting a firearm. And sorry, my computer malfunctioned for a second. There's also going to be prohibitions against inquiring as to whether somebody else is on the list or making a false statement to add or remove somebody. Interesting point. Specifically, the statute forbids discrimination against someone because they are or are not on the list for healthcare services, employment, education, housing, insurance, government benefits, contracting, past or present. So clearly, if you're renting a room out in your house, can you say to that person, you have to put yourself on the do not sell list? You can't do that. The statute says you can't. But I think under general contract law, you could say, but you will not have a gun in this house. But here's my question. I've thought about this and I don't have the answer. And I'm not here to give you just all the answers. I'm here to raise questions. Can the Commonwealth Attorney or a court make this a condition of a sentence or a plea bargain or a custody or a visitation order? Okay, Mr. Jones, I'll let you have every night, every other weekend visitation as long as you put yourself on the do not sell list. Or, sir, I will suspend your sentence as long as you put yourself on this list. I don't have the answer to that. So that's going to be one of those questions that may come up from time to time. One of the other things that was changed was, this probably won't affect many of us, but the appeal of an involuntary commitment order. You know that if a person's admitted involuntarily to a facility or ordered to a mandatory outpatient treatment as a result of a commitment hearing, they're barred from gun ownership. However, they have the right to appeal that case to the circuit court for a trial de novo. However, pursuant to the new statute, the effect would be to reverse the decision of the district court not to dismiss the Commonwealth's petition. On a practical matter, what does that mean? That means that even if the circuit court reverses the decision, the finding still stands, and that person will have to apply for reinstatement of their gun rights through the General District Court. Moving on to protective orders, the protective orders continue the prohibition against possession, etc., of a firearm, allows 24 hours for the firearm to be sold or transferred, and the person has to certify in writing to the clerk of the circuit court within 48 hours that they have complied. Failure to do so is punishable as contempt of court. Now, somebody asked before about restorations. Now we're there. Let's talk about restorations. What about for Bruce Abramski? No, not available. There is a statute that does allow for federal restoration of gun rights. However, it was defunded, as I recall, about 20 years ago, and it's never been funded again. So for your restorations, it won't be effective for a federal case. Section 18.2-308.2 does allow a circuit court to issue previously a permit to own, possess, purchase, etc., a firearm. Now it's a restoration as of January 1 of this year. Interesting point about this, I don't have the opportunity, I'm not going to take the time to look up the statute, but the statute says that the court has the authority to grant someone an unconditional restoration. What does that mean? Does that mean that the judge can't say, okay, I will let you have a restoration for long guns only? Does that mean that the judge is confronted with this choice to either say no to the restoration or yes to the restoration, and the judge can't impose conditions? That might have to be decided later on. The procedure for this is first the civil rights must be restored, then you petition the circuit court. Watch that venue. Residents of the state of Virginia, it's going to be where they reside. Non-residents, where they were last convicted. But remember this, they might have been convicted out of state. I just had one of these where the person was convicted in the state of New Jersey. They were convicted of concealing a weapon. In New Jersey, that's a felony. However, this was quite a number of years ago, and he was actually able to get an expungement of that. So remember, if you have an out-of-state conviction, you've got to go through that state first. I would ask you to be realistic about the chances of restoration, both as to the type of felony and the time expired since the conviction. I always have my clients complete either an online or some other type of no-touch firearm safety class. Clearly, they can't have a gun in their hands at this point, but you can find safety classes where the person does not touch a gun. Under the statute, no court appearance is required, but I always schedule one. I figure that if the judge is going to say no, I want to hear the judge say it. I want my client to hear the judge say it. And also, it gives me a chance to introduce my client to the judge, to have my client promise in person that, Judge, I will not do any harm with this weapon if you trust me. And I have my clients promise that they will take an in-person firearm safety class if they are granted this right. Remember the standard. It's for good cause shown. You need to put that, I think you need to put that in your petition. This is why this person wants his gun rights back. One issue came up in Prince William County. If a person is restored, are they eligible for a concealed handgun permit? And one of our judges didn't know the answer, so he denied that. And the case got appealed to the Court of Appeals. And it's an unpublished decision, but the Court of Appeals said, yes, the person is entitled to request a concealed handgun permit. But once again, it's the same standard, for good cause shown. Now, my position is that if the petition is granted, then you enter phase 2 of the representation, which is to send a letter to the client. And I mean a letter. And the letter is going to say, congratulations on your restoration. I would suggest that you carry this order with you just in case it's not on somebody's computer. Third, I cannot guarantee that you can possess a firearm in another state. I don't know what they would do in California. They may or may not. They need to check with a California lawyer or the California State Police. I cannot guarantee that the law will not change. When the Lautenberg Amendment, which is the amendment to the Gun Control Act of 1968 that disqualifies people from owning a firearm, at least a modern firearm, there were a lot of police officers, there were a lot of military personnel who suddenly could not do their job. The law changed. We also saw that in Virginia. In 2010, the Fourth Circuit ruled that Virginia's domestic violence statute did not trigger the Lautenberg Amendment. And that law stood until 2014, when in the Castleman case, the United States Supreme Court ruled that the Virginia statute did trigger the Lautenberg Amendment. So that was a situation in which the law, or at least the interpretation, changed. Now, with domestic violence convictions, try hard to get that 2-year SIS. We discussed this before. Does the 2-year SIS cause a loss of gun rights? In my opinion, it does not, because 18.2 57.3G applies to concealed weapons only. One thing I would ask you to do, Make sure your client acknowledges in writing that they're losing their gun rights forever. One of the reasons why I wrote this class is because I was tired of talking to attorneys who said, yeah, I represent people in domestic violence cases. What do you mean they lose their gun rights? Really? They have a term for that. It's called malpractice. Remember a guy by the name of Padillo? Mr. Padillo was a lawful resident, though alien in the United States, and he started dealing, as I recall, it was marijuana, charged with a felony. His attorney says, I got you a great deal. Mr. Padillo says, what about my immigration status? And the attorney says, don't worry about it. I got you a great deal. Well, later they tried to deport Mr. Padillo. The United States Supreme Court pronounced his attorney dumber than a hamster. It said he committed malpractice because he didn't pay attention to the fact that there was going to be a collateral issue here. We need to make sure that we're not in that situation where we're giving people bad advice. Now, we have a change this year. Last year when I taught this class, there was no state disqualifier. Now there is. There is a 3-year ban if a person is convicted of domestic assault and battery on a spouse, former spouse, or someone with whom they have a child in common. It will last for 3 years. This only applies to those to those offenses that occur after July the 1st. And it does also carry an automatic restoration. But one more time, we have a chance for people to get tripped up because somebody's going to hear that they lost their gun rights for 3 years. 3 years are going to pass, and now they're going to possess a gun and get charged under the federal statute. They're still banned under the federal statute. Let's take a moment and talk about what firearms that certain people can possess. For example, felons, domestic abusers, and persons subject to a protective order. This gets confusing. Make sure your advice is solid. Protective orders. If it's a preliminary protective order, they cannot purchase or transport the gun. If they have a concealed handgun permit, they cannot carry and they have to surrender their license. If that PPO becomes a protective order, then they cannot possess the weapon and they have 24 hours to surrender their weapons, and they're going to certify in writing compliance with the clerk of the court. All firearms are prohibited. Now, post July 1, 2021 domestic violence offenders and violent felons as defined in 19.2 297.1. All firearms are prohibited. They can't have any type of firearms. So now we come to that next category. What about non-violent felons and people who are convicted of domestic assault and battery for offenses that occurred before July 1, 2021? They can possess some antiques or replicas and up to 5 pounds of black powder if it's intended to be used solely for sporting, recreational, or cultural purposes. Did you notice something missing there? Sporting, recreation, or cultural purposes. What's missing? Self-defense. Can a person have a gun that is used for self-defense? And it's not in the statute. This is both in the state statute and the Gun Control Act of 1968. John, if you will, if you get a chance, can you put those pictures of the muzzle loaders up there and we'll talk about these?
Yes, we can. Just 1 minute though. Let's go over a couple of questions.
Sure thing.
How does one go about trying to get their gun rights back after an involuntary commitment through the General District Court?
Again, you have to petition through the General District Court. You're probably going to have a hard time doing that, but I was able to do one this past year. I was able to, the person had some psychological testimony, which we were able to get admitted by agreement, and they were able, but it's a petition through the General District Court.
And the second question is, I was under the impression that a restoration of rights in state court, assuming no other state bans, equal a federal restoration. Is that not the case?
I agree with you. I think because the Gun Control Act of 1968 says you're prohibited unless you've been restored by your state. So if you live in Virginia and you were convicted in Virginia and you get restored through the circuit court, then you're in good shape. Except I don't know what California is going to do. Maybe California says, sure, if you're restored in Virginia, you're restored in California. But I'd be real nervous about that.
Okay, so I've got what I believe is the first image up. Correct.
Okay. What you have here is a flintlock. And right there above the trigger, you will see the lock. So you got lock, stock, and barrel. Get it? That's where that expression comes from. That is a flintlock. Yes, the person who was convicted of domestic violence for an act that happened prior to July 1 of this year and the non-violent felon can possess this weapon. They can possess it and they can shoot it. Let's go on to the next one. All right, I don't know if you can see all of this. I can see it says percussion caps. Yeah, let's see those little percussion caps down there. All right, that's your primer. That's the initiator. That's what makes everything. If we can scroll down a little bit. Other way. There we go. A little bit more. All right, right above the trigger, you will see a nipple. That's where the primer fits on. Behind that is the hammer. This gun is legal for those persons that I just described. Let's move on to the next weapon. This is where it gets screwy, but I'm not criticizing. I'm just telling you, this is where it gets a little screwy. This is called an inline muzzle loader. All right, there's a straight line from the hammer right down the barrel. The person can possess this gun. Now, can you scroll down a little bit and show me the primer? What you're seeing here, that red thing, is called a dog bone extractor. That's used to extract the primers from there. The primers are down here. That's the initiator. These are what we call 209 primers. It's the standard shotgun primer. Here's the problem. ATF has ruled that while the gun is an antique, the primer is modern. So therefore, your client, your non-violent felon, can possess the gun, but they can't possess the primer, so they can't shoot it. So tell them, don't even think about it. Don't possess that. And then finally, you get to the last gun, which is called a convertible. This is looks like the Remington 700. This gun acts very much like a modern weapon. According to ATF, it is a modern weapon, and these people, these individuals, cannot possess that gun. Now, when you impart this information to your client or your friends, I would not do it by oral statement alone. It's too confusing. I get confused on this stuff. So give them an opinion letter. Give them an opinion letter that says, this is the disqualifier as you have described it to me, and limit your answer to that particular disqualifier, and then explain the 4 types of muzzle loaders. And on top of that, caution them about re-entry to the gun culture. You know, the most normal thing on earth. You're sitting around the hunting camp and somebody has a gun out and you say, hey, can I see that? That's going to put them in trouble with the law. And then also, once again, the geographic limitation. All right, I'm going to stop there so I have time on these other topics. Any questions on this? And there could be 1,000 of them because it does get complicated.
I think perhaps too complicated. Nobody had a question about it. Let me throw one in on my own. Do you have an opinion about people that are prohibited from owning firearms, whether on a limited or a complete basis, having so-called non-functional firearms? Not so much the one where just the the firing pin has been removed. Obviously, that's not going to work. But I'm talking about that have them that have been converted to other uses. I seem to recall the Court of Appeals had a case a number of years back where the firearm had actually been converted into a lampstand. And there was a question about whether or not it was still a firearm. And then, of course, the other thing is so-called replica weapons that would be similar to the actual weapon, but would be for collector purposes and not functional.
That's a tough question because so often, if you look at these statutes, the issue becomes what was the gun designed to do? So that's why non-functional guns, a gun that is broken or malfunctioning, it still qualifies as a firearm. I would say if you made, and I'm guessing here, this is just a guess, I would say that if I turned a pistol into a cigarette lighter and I totally changed the design of that so it was completely impossible for it to be used as a firearm, or anybody would look at it and say it's not a functioning firearm, you would probably be safe. But that's a guess. That's speculation. I'd like to see some cases on that.
Yeah. Then we did have a couple of questions come in.
Except for me.
It says, what about antiques made prior to 1898? And then also, are muzzle loading handguns okay?
Once again, whether and it sounds to me like that person has either read the Virginia statute or the Gun Control Act of 1968, because they both use that language about firearms that were made before 1898.
And then another question: do non-explosive guns like BB guns, pellet guns, pneumatic guns, do they fall into the prohibitions as well?
I think you have to look at the particular statute. We're getting ready to cover that on schools in just a moment, and that might be helpful. Maybe we can address it there.
Okay.
Um,
All right, I think we're ready to
Again, I would want to look at the
yeah, we need to.
I would want to look at the criminal statute. Go ahead. All right, let's go on to children safety and firearms. I'm going to skip this section on what I was going to talk about. There was the fact that you have to be careful about telling people if they can move. You need to find out where they're moving to. That's one of the things. When you have a gun, you always have to keep thinking. You know, I was up in Winchester, last year, and I had a handgun in a case, unloaded, in the back of the car. So everything was safe. And my wife suggested, how about if we run over and see my brother for a few minutes? And I said, hey, that sounds fun. Let's do it. Until I realized he lives in Laurel, Maryland, or somewhere over there in Maryland. And I thought, oh, great, I'm about ready to cross the border. So we had to run home and ditch the firearm. You just have to keep thinking all the time. Let's talk about school property. There's been an amendment to the statute because they added some of the places where guns are prohibited. So now daycare centers, private and public preschools were added to regular schools as places where one cannot possess a firearm. It's a class 6 felony. And then if within the building, the person has the intent to use or attempts to use or displays the weapon in a threatening manner, then there's a minimum mandatory 5-year sentence. Knowingly possess the school on firearm on school property. You have to know that you're on school property. That may sound ridiculous, but I'm going to cover that in just a second. Now, this is a situation where the statute does define what we're talking about. The statute says the firearm must be designed or intended to project by means of an explosion of a combustible material. All right, so a BB gun wouldn't count. Any type of air gun wouldn't count because it's not the explosion of a combustible material which is setting the projectile in motion. However, it would cover a non-functioning weapon. If the gun is malfunctioning, doesn't matter because it's what was it intended to do. It also means the statute says that it's on the property, not just the building, or the portion of any property open to the public used exclusively for school-sponsored functions or extracurricular activities. Covers school buses. Now, there's particular provisions with respect to child daycare center, which is a licensed daycare center, which is not the home of any provider of any of the children, public, private, or a religious preschool, or a daycare center. Here, the rules only apply during the operating hours, and it doesn't apply to someone whose residence is there. But be careful because we have some other statutes to go over. One of the things I find interesting about this is I know what they were doing. I know what the General Assembly said when they added these other schools, but I'm thinking of my high school, Annandale High School in Fairfax County. It's a big brick building that looks like a schoolhouse. It's got a sign out front that says this is Annandale High School, and the entire property is surrounded by a fence. There's no way you could say, I didn't know it was a school. But across from my farm in Shenandoah County, there's a 46-acre farm, and it's my understanding they have a co-op school there. And also I looked at the tax records, there's about 4 or 5 different lots that were put together to form this 46 acres. Does that school co-op school count? Again, I'm just trying to alert you to the fact that it can be a real complicated issue. You need to find out what kind of school it is and see if it's defined in the code, and to determine whether it matters that there was no marking there, because on that co-op school, there is nothing saying there's a school there. Now, there are some exceptions. Once again, we talk about the fact that these gun laws are a bunch of thou shalt nots. Well, there's also things that you can do. For example, if I go to pick up my grandson from school, if I have an unloaded firearm in a closed container, which includes a locked trunk, I'm legal. What about an unlocked glove compartment? I got to tell you, that gets to be a shaky area, particularly if I'm going to have my grandson in the car. So I would say that glove compartment should be locked. Also, if you have a concealed carry permit, you can have your gun on your hip while you go into the school property. However, you've got to be in a usual or traffic parking area. You've got to remain in the vehicle. The problem is here is that little Johnny asked you to help load the saxophone in the back of the car. And next thing you know, you're out of the car and you're violating the law. Also, interesting enough, it doesn't apply to an unloaded rifle or shotgun in a firearms rack in or upon the vehicle. Shotgun racks are not as popular as they were. I think a lot of thieves put an end to that. Storage of firearm in home daycare centers. During the hours of operation of licensed, registered, or approved daycare centers, the firearms must be stored in a locked container, compartment, or cabinet, and the ammo must be stored in a separate locked cabinet, compartment, or cabinet. Now, there's a lot of cases out there about what is a cabinet, for these purposes, and particularly with the safety of children involved and what is at stake here, I would say don't rely on a gym bag and say that's a compartment. Make sure it's a hard case. Best yet, a gun safe. And I think that most gun safes also have an ammo safe inside, but if they don't, remember the ammo has to be stored separately in another container. So that might mean if you don't have an ammo safe in your gun safe, that you cannot rely upon that. There was an interesting case that came out of the Court of Appeals in 2019. I'm having trouble reading my writing. It's the Myers, M-Y-E-R-S case. It was an unpublished decision, so I don't know that it has any precedental value. But that was a situation in which the court talked about whether or not a backpack would be considered secured. I would not rely on that case. I would rely on hard cases when you're dealing with children. I want to just throw in a little word about gun safety. You know, sometimes we gun owners, particularly those of us who are a little long in the tooth, have a tendency to wax on about the good old days when they didn't have all these dadgum laws. You know, you didn't have blaze orange, you didn't have to have a gun safety class, and didn't have all these storage requirements. Well, let me just say that back in the good old days of, let's say, 1970, there were 2,406 accidental gun deaths in America. The last year for which I could get the figures was 2018, and there were 468 accidental gun deaths. But in that time, in those 48 years, the population went from 203 million people to 327 million people. You know, if we had the same rate back in 2000, if we had the same rate that we had back in 1970, we would have about 3,900 people dying from gun deaths each year. This is about an 88% reduction. So when you're talking to people about safety, if you start to get some of that noise, you might want to look at that and say, you know, some of this stuff has really worked. The number of gun deaths has gone down. Earlier, we were talking about children and guns. 18.2, 56.2. This is the statute in paragraph B, Bravo, that says it's a class 1 misdemeanor to allow a child under 12 to use a firearm unless the parent, guardian, or person in locus parentis, or a person who's 21 or older who has the permission of the parent, etc., is with them. A, it's a class 1 misdemeanor to recklessly leave a loaded unsecured firearm in a manner so as to endanger life or limb of any child under 14. There was a case that came out of the Court of Appeals, and this is a published case. This was a 2004 case, an accidental shooting by a 14-year-old of his 11-year-old friend. The 11-year-old friend lost an eye. Now, the Commonwealth in that case relied on 56.2, dealing with their ages, but they also used 18.2, 371.1, which reads that any parent, guardian, or other person responsible for the care of a child under 18 who by willful act or willful omission or refusal to provide any necessary care for the child's health or causes or permits serious injury to the life or health of such child is guilty of a class 4 felony. This gives the Commonwealth another tool to use. If it doesn't qualify under that 56.2, I think it was, then maybe it qualifies under this general statute. Now, in this case, the Court of Appeals found that because the 14-year-old had received firearms training, that the father was not guilty. But which standard would apply? Would it be the 56.2 with the ages or the more general statute? This is something you need to be aware of. Also, you need to be aware of the Youth Handgun Act. There is both federal and state statutes on this. One change was made by the General Assembly, which was on the school boards, new statute to prohibit school boards from allowing people such as teachers to carry firearms other than as allowed in the code. And then for this section, I'm going to conclude with places of worship, 18.2-283. I don't have that statute in front of me, but it says essentially that no person shall carry a firearm into a place of worship without a good reason. Well, that's kind of general. The Attorney General a number of years said that self-defense was a good reason, but he also said that churches could ban those. And it's hard to tell how a judge would interpret that particular statute. So I would say if you are asked by your church, your synagogue, or your mosque, or your other place of religion about this law, find out if they're looking for legal advice or security advice. And then also be careful. What rules apply? Church, school, or daycare? For example, at my Baptist church, we have something called the We Center. It is a child daycare center that operates Monday through Friday from 9 to 12. What rules apply, daycare or church? Next door, we have a Catholic church and they have a school there. What rules apply, church rules or school rules? I respectfully submit that the more stringent daycare or school rules would be the ones that apply. That concludes that section. Any questions or comments?
I have a question.
Joseph, no, you don't.
I need to ask.
No, you don't.
I just need
No
to know.
comments or questions from the audience.
No, I mean,
Where are we, John?
We've got 17 minutes, brother.
and
Oh, were there any questions that you saw that you wanted to go over?
well,
No,
actually, well,
Joseph,
actually,
no questions at this time.
Okay. All right. I want to go finish up with the red flag law. Hey, can I ask a question? We've got a minute or two here. Have y'all handled any of these? I sent out a letter or an email to the 500 members of the Prince William County Bar saying, if any of you have had one of these cases, I would really like to hear about it because I'm going to be teaching about this and be nice to know that I'd had one of these cases once. Anybody had one? Okay.
No one is chiming in, so I'm guessing that's a no.
I don't think so.
Sorry, what kind of cases again?
Red flag?
Red flag law case.
I've had a red flag case, but only in Maryland, not in Virginia.
Okay.
But it's very similar, and it's kind of crazy because they're ex parte to begin with.
Well, I'm getting the impression this law is not being used very much, but let me go ahead and talk about this. First, I'm going to start off with a few statistics, but you always have to be cautious when you hear any statistics, but in particular, gun statistics. Andrew Lang, often statistics are used as a drunken man uses a light pole, more for support than illumination. My stats are from the World Book Encyclopedia, World Book Almanac, and I trust them. In 2020, suicides fell by 6%, which was good news because it had been climbing steadily before that. But still, there were almost 45,000 suicides. For ages 10 to 34, it's the second leading cause of death. I want you to think, as we approach the 4 o'clock hour, I want you to think where you were yesterday at 4 p.m. As you do that, just think about the fact that since that time, 123 people in the United States have killed themselves. And about 61 to 62 of those use guns. Frankly, I suspect that the number is higher. Every year, there's 169,000 people who die by accidents, and I suspect that some of those accidents are really suicides. For those of you who are a little bit older, you may remember the movie and TV show MASH. It had a very popular theme song. Remember the title? The title was Suicide is Painless. Suicide is anything except painless, but it is contagious. And when you see that figure of 45,000 suicide deaths in 2018, I would like you to think of the oldest joke in the Navy. Far at sea, two sailors stand on the forecastle looking at the ocean. The first one says, "Sure is a lot of water out there." And the second one says, "And that's just the top of it." The suicide deaths are just the top metric. It doesn't tell us about the number of attempts, doesn't tell us about the family members, doesn't tell us about the friends who not only have lost a loved one, but maybe they were the ones who discovered the body. About half of all suicides are committed with firearms. Did you know that women have an attempted suicide rate 4 times greater than men? Did you know that men have a suicide fatality rate 3 times higher than women? Where's the discrepancy? It's because so often women use pills with a 2% fatality rate, and men use guns with an 85% fatality rate. So when you see that 60% of all firearm deaths are suicides, think about this. I personally think that the figure might be as much as 2/3 if you were to include murder-suicides, suicide by cop, and mass shootings in which the shooter intends to die. It's a tremendous problem. So the emphasis on this law is to try to prevent that. I'm not advocating for or against this statute. I'm just saying that we have a tremendous problem, and hopefully this statute will reduce the carnage, though it does appear that it's not being used very much. We begin with talking about the emergency substantial risk order. The following is opinion. California has a red flag law that allows teachers, co-workers, and employers to file these petitions. I wonder if some employers might file these petitions just to protect themselves from liability. I see other problems with that. In my opinion, for what that's worth, when the General Assembly of Virginia wired this particular machine, they installed a circuit breaker. That circuit breaker is the fact that the petitioner must be a law enforcement official or Commonwealth's attorney or deputy. I think that should reduce some of the abuses we have seen with other types of protective orders. When we review this statute, we see that the applicant must be a Commonwealth attorney or law enforcement officer, and that the petition must be under oath and supported by affidavit. Those of us who work with other types of protective orders know how important that affidavit is. We get to compare with what's being said in court with what was said under oath at the time of the incident. Bar complaints. For 6 years, I served on the 5th District Subcommittee. At an ethics seminar a few years later, I suggested that bar complaints should be required to be under oath. I was advised that I should sit down and quit bothering people. So the application has to be to the circuit or the general district court or the juvenile court judge or a magistrate. Once again, it's going to be on an ex parte basis, and the standard is going to be substantial risk. Let's state the absolute obvious. The petitioner is a law enforcement officer or prosecutor. The subject is not present. The order is going to be granted. But it still requires an independent investigation by law enforcement personnel. Again, my opinion is this serves as an important protection for the subject of the petition. Frankly, police officers and prosecutors tend to be a little skeptical. They're accustomed to people lying to them. Now, whether you're defending this case or bringing this as a prosecutor, you're going to want to look at that defining section. It can't be that the person's delightfully nutty. You have to show that they committed an act of violence, force, or threat, as that's defined in 19.2 152.7:1. If this is granted, the subject may not purchase, possess, or transport a firearm for the duration of the order, but they can voluntarily surrender the weapon. Otherwise, seizure and retention of the firearms will take place by law enforcement with court approval that can be transferred to another person. It obviously requires the surrender of the concealed handgun permit. And just like with other protective orders, it's going to expire on the 14th day at 11:59 p.m. or when the circuit court is next in session. The subject of the order can petition the court at any time to dissolve the order. Notice the venue. The venue is anywhere where any of the offending behavior took place. Now, if they move past that, we're going to go to the substantial risk order, and the Commonwealth attorney, again, will be representing the Commonwealth. The subject is entitled to a hearing, and the burden is on the Commonwealth to prove all material facts by clear and convincing evidence. Again, look at that section that defines what behavior qualifies. Make sure that the behavior falls within one of those pigeonholes, or if you're defending, make sure that it doesn't. Interesting point. The rules of civil procedure apply. And when it does, that means hearsay objections can be made. So unlike a probation hearing where hearsay comes in, hearsay should not come in. Now, the initial order can be issued for up to 180 days. And prior to the expiration, the Commonwealth or a law enforcement officer can file a written request to extend the order. Question, if they don't and the order expires, do they have to produce new evidence to have a new order entered? I'll leave you to consider that. And the next thing that we have is my computer jumped a little bit. There's no limit on the number of times it can be extended. It can be extended for another 180 days based upon clear and convincing evidence that the subject continues to pose a risk. Now, let's look at the practical side of this statute. The emergency order has already been issued. Now you've got 14 days to prepare for the what we'll call the due process hearing. Is that going to give you enough time to present a defense? Maybe you wish to extend that period of time to get some psychological evidence or have your client undergo some treatment. So you need to consider, do you want to ask for a continuance while keeping the emergency order in effect? The statute specifically allows for that. Now, the court can allow the weapons to be transferred to a person 21 or older, and then it has a couple other things that I like about it. 19.2, 152.15, the weapons shall be returned upon court order or upon expiration or dissolution of the order, and they shall be returned within 5 days upon written request. I like that because some jurisdictions have sort of informal rules for protective orders, like the police will go ahead and keep them for a period of time, even if the protective order was denied and the preliminary protective order dissolved. But this statute does require a written request. So if no written request is received within 120 days of the dissolution of the order, whoever's holding the guns can go ahead and have them destroyed. One more thing that I like about this is the false statements. Any person who knowingly and willingly makes a materially false statement or representation to a law enforcement officer or attorney for the Commonwealth is guilty of a Class 1 misdemeanor. I think that's an important protection. And then I want to close with this question, and that is, are you required to take these cases? It is a civil case. So if you have a client who you're looking at them and you're thinking in your mind, I would not want this person to have a sharpened butter knife, much less a firearm, do you take that case? Or do you take the position that, you know, on this entire earth, maybe I'm the one person that they will talk to and listen to. Maybe I can get them into counseling. That's an ethics issue. And one of the things I like about ethics is so often there's not a straightforward answer. So that's something that you have to decide for yourself. All right. And at that, it appears that it is 3:56. My time trial said that I would end at 3:55. So we have
Hold on
4
1 second.
minutes to straighten out whatever mess. Do what?
Okay, we're good, but we did have one question going back to the previous section that came in.
Sure.
It says, does it matter if the church rents out the building to other organizations such as the YMCA or Boy Scouts? So if the church is being used for a let's call it non-religious purpose, does that make it not a church? That's a law school exam question if I ever saw one.
I think it's a church. I think if it's regularly used as a place of worship, then the fact that they may have a dance there. Our churches in Annandale up in Fairfax County, when I was in high school, they would have a dance for the young people that I would occasionally go to. Goodness knows it wasn't in my church because I am a Baptist. But some of these other religions, they do allow some dancing in the church. But I think it was still a church. I think if the Boy Scouts are meeting there, it's still a church. I think if the church has got a building off-site that they don't use for religious reasons, they have it as an investment, or perhaps it was a place where the pastor lived, I think that's different.
Okay, so somebody also asked, and again, I think this is a little off topic, but perhaps if you could just say a little bit more about what a gun trust is. I'm assuming it's a trust that's meant to keep individuals from having possession of a gun while being used for some other purpose.
It is usually used for the transfer of National Firearms Act guns. But again, before I teach the seminar again, I guess I better find out. It's kind of like the last seminar, last time I taught it. The question came up, are binary triggers legal in Virginia? And I gave a really good answer to that. I said, that's a good point, and I think that deserves further review. And within a week, I went out, looked up, and found out what a binary trigger is. So no, I'm not familiar with gun trust, but I do believe they're more or less related to the NFA weapons. Sorry about all the initials.
All
NFA,
right.
Somebody
after
just
John
posted,
Dillinger and Bonnie and
posted
Clyde.
the link, which is, I assume, to about gun trusts. I'll take a look at that and see.
Okay.
Or maybe not. I don't know. It's something in the Trust and Estates newsletter. Anyway, so I want to thank Greg for his time and his participation. And he has said that he will offer this course again, since we had so many people sign up for it in our fall session. I hope that's still true. And
It is.
Okay, good. And for everybody else who's out there, if you did not get the written materials or the CLE form from the links, we're going to get that all straightened out. And later this evening, probably between 9 and 11, when I get back to the hotel room here, I will make sure that that goes out to everybody whose attendance is confirmed. If you do not receive an email from the VMVLA with your form saying, and your written materials saying that your attendance has been confirmed, then please contact us. We always seem to have more trouble with people getting their forms going to spam filters than anything. I think it's because of the attachments. But at any rate, yeah, the emails will go out this evening, and hopefully everybody will get them. But never say never. So if you're one of the ones that don't get it, just make sure you get in touch with us, and we'll make sure you get it. This is our last CLE until the fall seminar starting in October. We're taking the summer off like the appellate courts do. We will be sending out emails about the fall seminar, and of course the meeting in Harrisonburg. Registration for those will start sometime after the 4th of July break. If there are no other questions for Greg, I see lots of thanks coming in, and of course we always appreciate knowing that we're appreciated, but lots of thanks for you, Greg. And so Joseph did want to ask a question. I'm not sure what about it. Go ahead, Joseph.
Greg, I did need to ask you a quick question.
Sure.
I just realized that what I was going to say is that there were police officers at Hidden Valley Middle School and Hidden Valley High School. They were supposed to have a police officer at all the stores and all these places. They were supposed to have some of those because I don't want them to get any more trouble.
Yeah, what is your question? Because
do you know if do you know if they can have a police officer at like at the stores or like any workplaces, because they need to really not go without one with like one of these Roanoke County schools like this. Do you have a question about this, Greg?
I'm not sure exactly what the question was, but police officers in schools, for example, I got that question. They are exempt from the no firearms law. There's a provision there that says policemen can carry guns there.
But they need to.
I assume that police can carry their firearms even in stores where they say no firearms. Is that correct?
Well, as a matter of fact, there is now a federal statute that allows police officers from one state to carry just about everywhere, but not everywhere. Because a number of years ago, I guess that was like 2 or 3 years ago, I was going through the Holocaust Museum in Washington, D.C. And right behind me was a Montgomery County police officer, and he was trying to bring his weapon in there, and the federal agents told him he was not going to bring his weapon in there, and he cited the federal law. And all I'm going to tell you is they won. He was not able to bring his gun into the Holocaust Museum. So for the most part, if you're a sworn law enforcement officer, you can go across the country and carry your firearm subject to certain provisions. New Jersey has some restrictions. Hey, John, I wanted to throw one more thing. If anybody has questions, I'm happy to answer these things. I don't know if you gave them my email address. I'll be happy to answer the questions. It's how I learn. John, you're muted.
Okay, Joseph was saying he had another question, but I'm not
one
sure
more-
what it is.
one
Joseph,
more-
let me finish up first.
Okay,
Okay.
all right.
All right. So thanks again, Greg, and you know, for everybody again, thank you for spending a little bit of your Monday afternoon with us, and we'll look forward to seeing everybody back in October. And so
And Greg,
we'll be saying goodbye.
And Greg, please make sure that you send a police officer so they can stay at the store so they don't get into trouble, please.
If he has a police officer, ask him. He'll let
Please
him know.
do, please. And I do really appreciate it.
Okay.
Thanks so much, everybody. Thank you for coming. I do appreciate it.
Well, thank all of you.
All right, thanks. Bye-bye.
Bye-bye. And we're going to be
Okay, take care.
in 3, 2, and 1.